liberty and justice for all.
Thank you. This morning, before I make our usual general announcements, I also wanted to announce the resignation of Commissioner Cummings from the commission. He left, unfortunately, commission activities kept interfering with important private matter duties and family duties, and so he has resigned. I know I will miss him very, very much. He was like E.F. Hutton. He didn't offer a lot, but when he did, everybody listened. And so he was a valuable member of this commission, and we'll miss him and wish him good luck. I've got some preliminary housekeeping announcements. The first DCA graciously lets us use their facility, so please respect their rules and have absolutely no food or beverage other than the water that is in this room. Please go ahead and silence your cell phone. Anyone addressing the commission, please speak up so our recording equipment can pick you up properly. And my fellow commission members, please speak up and into the microphone so you can be heard. I ask that you be as brief and concise as possible in your questions and comments, as we have a number of items for consideration today. Pursuant to law, members of the public have the opportunity to have input on matters before the commission other than in cases in which we act in a quasi-judicial capacity. This means the public can have input on matters other than complaints, opinions, and determination in financial disclosure cases. If you desire to be heard on a matter, please fill out a speaker card and give it to Ms. Fulford, who has her hand up in the back. First item up is the approval of the December 3rd, 2021 public meeting minutes. Do I have a motion?
I move they be approved as circulated.
Second.
Second. Motion by Commissioner Grant, second by Commissioner Gates to approve the minutes. Any objection? All in favor say aye.
Aye.
Show that move. Our first matter on the agenda are consideration of final actions. DOAH recommended orders. The first one, case number 18-090, has been granted a continuance, so we will proceed to item 19-174, NRA Spod. We have before us the recommended order of the Administrative Law Judge for the Division of Administrative Hearings in referral number 19-174, NRA William Bill Spod, recommending that the Commission find the respondent violated 112.3136 Florida statutes, and for that violation recommended public censure, a reprimand, and a civil penalty of $5,000. The respondent timely filed written exceptions to the recommended order. Thereafter, the advocate filed a response to the respondent's exceptions. The exceptions, the response, and the full record in this matter are included in your meeting materials. We also have a draft final order recommended by our staff, which rejects the respondent's exceptions and adopts the recommendation of the Administrative Law Judge. The respondent and the advocate will be given 15 minutes for argument. The respondent will argue his exceptions, and the advocate will argue her response. Commission members are free to ask questions at any time. Then we'll have discussion, questions of staff, if any, and a motion on adoption of the staff's draft order. Under the Administrative Procedures Act, we are unable to reject or modify a finding of fact unless we determine that there is no competent, substantial evidence to support the finding. And if we reject or modify a conclusion of law, we must find that our substituted conclusion of law is as reasonable or more reasonable than the ALJ's. With respect to the total penalty recommended by the ALJ, the Commission may, upon review of the full record, reduce or increase the recommended penalty, stating with particularity the agency's reason for the increase or decrease. Will the parties or their counsel please identify themselves for the record?
Dylan Rivers on behalf of the respondent,
Thank you. Would you like to come to present your argument? Thank you. You are recognized.
all set, Madam Chair.
You're recognized.
Morning, Commissioners. Again, my name is Dylan Rivers. I'm with the law firm Osley McMullen here in Tallahassee on behalf of William Spaulding. Mr. Spaulding is the mayor of the city of Bushnell, Florida, and I'm going to give you a tiny bit of background just because I think it's important, and they are obviously, it was a record that was not developed before you, but rather before the administrative law judge. Bushnell is a small town by any measure. It's less than 12 square miles in size, and according to the most recent census estimates, it has a population of 3,183 people. Like a lot of small towns, people know each other. Sometimes that's a good thing, sometimes that's a bad thing. I mention all this because it's important to understand that Bushnell operates like a small town. There are ways of doing things that might seem unusual or even unheard of in larger cities. That's true in the city government as well. The city of Bushnell government is not a large operation. There are employees who serve multiple roles. There are processes and procedures that were discussed on the record in this case that are sometimes followed, sometimes not followed, or loosely, if at all. There are billing and record-keeping issues that came up in this case. And all of this is in the record, and I won't belabor the point, but it does give context to the operative facts and the actions of Mr. Spaulding that are at issue in this case. Specifically, we're talking about two issues that remain before you where the administrative law judge found a violation. One is Mr. Spaulding's borrowing of some pipe and tapping saddles from the city. Two, his use of the city's account at a industrial plumbing supply store called Core and Main. The city's account was used to purchase items when the power was out, so his credit card could not be run. Now, these things, again, may seem unusual, perhaps even admittedly unadvisable, given Mr. Spaulding's position as mayor. But if they weren't done corruptly, as is required for a violation of Section 112.313(6), then there's not a violation of the Ethics Code. Receiving a benefit in and of itself is not a violation of the Ethics Code. Doing something unusual or potentially unadvisable is not a violation of the Ethics Code if the actions weren't taken corruptly, and of course that term is defined in the law. So getting to the heart of the issue, we would submit that there's two reasons why we're here. One is that we would submit that the record does not contain competent substantial evidence to support any findings of corruption. And number two, the way in which the law was applied with regard to the required element of corruption, we would submit is not consistent with the statutory definition or the case law interpreting it. Starting with the pipe and tapping saddles, they were returned, and this is all, of course, in our exceptions, and I won't repeat everything that's there, but in summary fashion, the pipe and the tapping saddles were returned to the city unused, and Mr. Spaulding's uncontroverted testimony was that if he had used them, he would have paid the city for them. And the record also reflects that this is something the city had actually done, that if a citizen needed certain industrial type supplies that were not readily available to them through other means, that they could come to the city and the city would sell it to them at cost. So Mr. Spaulding did not receive some type of benefit that was not available to other citizens. But again, he returned everything unused. Again, this might seem unusual, but this is the way the small town city government operated. With regard to the Core and Main purchase, The power was out when Mr. Spotty presented to the store, which, by the way, was about a half an hour from Bushnell, but he couldn't find the materials he needed anywhere else. So he went to this location where Corin, Maine has, larger industrial type plumbing supplies typically sold to contractors and governments. When he presented to the store, their power was out due to a hurricane, so they couldn't take his credit card or use typical registers, but they were open and operating, and the only means by which a purchase could be made is on an account. And here again, because the power was out, there was no way to generate a receipt or an invoice, and so a handwritten note was given to Mr. Spotty that certain items were being purchased on the city's account. It didn't list amounts, it didn't list dollar values, sales tax amounts, or whether sales tax was even being imposed. Mr. Spotty purchased the items and immediately informed the city. There was no attempt to hide any of this. He informed the city and immediately paid the full amount that was charged. Paid it directly to Corin, Maine. The city didn't pay for him, and then he reimbursed the city. There were no city funds ever used. And with regard to the sales tax, there's no dispute that sales tax wasn't paid. We're not here arguing that. But he didn't know that. He didn't know whether sales tax was or wasn't being charged, much less how much he should have paid. He just paid the full amount that was charged on the account. And so not knowing whether he was paying sales tax or not, how can it be said that he did so with corrupt intent? There's no evidence that he went to the store intending to use the city's account, that he knew the power was out, or certainly that he knew whether or not he was paying sales tax. Did all of this happen? Yes, it happened. But we submit to you, there's simply no evidence that he did any of this with any kind of corrupt intent. There was no evidence of any intent to steal from the city, defraud, or take anything that didn't belong to him. Now, the advocate has pointed to testimony saying that the mayor is not permitted to make purchases under the city's purchasing manual, but there's two major problems with this. The first is that the purchasing manual doesn't actually say that, and it's quite remarkable that we have a recommended order that points to testimony about this purchasing manual, and we then have a proposed final order, a draft final order that is here before you that also relies on this purchasing manual. And yet the purchasing manual itself was never, the text of it was never discussed, never looked at, never referenced. It's in the record. It is an exhibit in this case. And the purchasing manual just simply doesn't say that. It doesn't reference the mayor at all in any way, shape, or form. So we would submit that any finding is simply contrary to the actual record evidence of what the purchasing manual says. The purchasing manual was entered into evidence by the advocate, presumably for a reason, and yet the actual text of it, the actual substance, is not quoted, referred to, or relied upon in any way. Rather, it is a statement from a witness who said, well, what he did was contrary to the purchasing manual. Okay, what provision? Where? What was violated? Because that is not in the record, and it's not in a finding in the recommended order, and it couldn't be, because when you read the purchasing manual, it speaks in terms of the city's procurement processes and how to avoid conflicts of interest with vendors. Like all municipalities, they have a procurement policy and a process. It doesn't say anything about who can use a city account, the mayor or anyone else for that matter. And it's frankly astounding that there's reliance upon this purchasing manual for findings and conclusions in this case. It's an exhibit in the record, and yet the actual contents of the purchasing manual were never quoted, never referenced, and never specifically relied upon. It was the statement of a witness, which is contrary to the actual manual itself, which is in the record. The second problem here is that the purchasing manual is not law. As the Commission's aware, the case law interpreting the corruption element refers to a violation by someone who would have been on notice that their actions were in violation of the law or the code of ethics. Purchasing manual is not a law. Here again, if we want to accuse my client of doing something that was unadvisable, that he, given his position, he would have, should have, could have thought differently and done differently, but he didn't violate a law, and he didn't do anything with any kind of corrupt intent. So turning to the application of the law, we would submit that the recommended order misstates and misapplies the law as it relates to the element of corrupt intent. The recommended order, as well as the draft final order before you today, they don't actually make express findings or conclusions of corruption or corrupt intent, but rather refer to Mr. Spotty's conduct as being, quote, improper, and that he, quote, knew or should have known that what he was doing was improper. But I would submit to you, even if we admit that as being true, that's not the definition of corrupt, or corruptly rather, statute. Here again, the mere receipt of a benefit by a public official is not a violation of 112.313(6). Doing something unusual or unadvisable, or to use the word that's in the papers before you, quote, improper, which is not defined in any way, doing something improper is not a violation of 112.313(6). Doing something corruptly is, and there's not any findings or conclusions that my client took any action corruptly, at least nothing that's consistent with the definition of that word in the law. Corrupt intent has been described by the courts as the, quote, touchstone of a violation of section 112.313(6). And I would submit to you that it can't be treated as having been satisfied unless there is, to use the applicable legal standard, unless there is clear and convincing evidence of that, and unless the law is applied consistent with the language of the statute and the case law that interprets it, and we don't have that here. And the last thing I'll mention, Commissioners, is the exception that we took to the penalty. Obviously, we would submit no penalty is warranted because no violations have been proven, but assuming there is to be a penalty, we believe that the one that has been proposed is out of line with precedent. We've cited some cases, and I won't go through all of those here again today, but the cases that we cited as prior cases and prior precedent of this commission, they aren't even addressed in the advocates' responses to our exceptions or in the proposed final order before you. They're essentially summarily dismissed as, well, yes, those are precedents, but we feel like we've done what we need to do here. And I don't think that the prior precedents of cases from this commission involving violations of the same statutory provision should be disregarded. I mean, you have precedents before you where violations of the same subsection of the statute, where restitutions and penalties or fines are set in a manner that is commensurate or reflective of what actually occurred in terms of a financial gain or a financial loss. There's some measure of the punishment fits the crime, so to speak. And here we have a grand total that the record evidence says this, I'm not saying it, a grand total of violations that do not even amount to $100 in a financial benefit. And yet we have a $5,000 penalty, and we would submit that that's simply out of line with any sense of fairness as well as the precedents of this commission that we've cited in our papers. And I'll yield the rest of my time. Thank you.
Thank you. Commissioners, are there questions of the respondent?
I have one question.
Yes,
Sir,
sir.
your comments have been very interesting and very compelling. Is that the same argument that you presented before DOA?
Well, in the sense of the evidence that we put on, I would say yes, but obviously I wasn't making arguments as to a finding being wrong because I didn't have, the findings at the time. But yes, the crux of our position in this case was not to challenge what did or didn't happen and dispute facts as much as it was that, yes, this stuff happened, but it wasn't done corruptly.
So what you said today is basically what you said to DOA, and and the administrative judge disagreed with you.
Well, given the recommended order, I would say that's a fair assessment.
So you're asking us to find basically that the administrative judge was wrong.
Well, what I'm submitting to you is that with regard to any factual findings, that I don't believe that there's record evidence to support those findings. And with regard to the application of the law, obviously I'm moving off of facts and now talking about the law, that I believe that the recommended order does not apply the legal element of corruption in the proper manner. Now, obviously, those are two different standards with regards to factual findings and conclusions of law. But so I suppose the way I would frame it is I'm not quibbling with the administrative law judge in the sense of you would have, should have, could have found for me on a particular issue, but rather I'm saying there are findings that go against my client that I don't believe have record evidence to support them, and there are conclusions of law that I think are inconsistent with the law as it relates to the element of corruption.
Well, we have no ability legally to change the facts or the findings. They are what they are. And the administrative judge examined those as they were and came up with a conclusion. And based on the judge's conclusion, we have before us a recommendation. And I still think what you're trying to do is reinvent the wheel and say, you know, notwithstanding what the administrative law judge did, we want the Commission on Ethics to do something different. Is that correct?
Well, I think it's fair to say that anytime someone is filing exceptions to a recommended order, they are coming to the agency, in this case the Commission, or they are coming to the agency saying, I don't believe that X, Y, and Z in the recommended order is correct. Now, you know, again, I don't want to I guess I would analogize it this way. I think we have fact findings that relate to this, to use the example of the purchasing manual again, analogize it to a contract. You know, if you have a contract case and a judge makes findings saying, well, the contract says this, that, and the other, but you actually pick up the contract and read the actual exhibit itself and it doesn't say that at all, I think you can overturn that finding, because there are findings and then resulting conclusions from those findings based on reference to a document, but when you actually pick up the document, it's not what it says. And so that's the basis of the argument, to say that it's not supported by clear and convincing evidence in the record. I would say it's not an absence of evidence, it's contrary to the evidence. It's not even just an absence of evidence. It is, the recommended order says something that is simply wrong.
Thank you, sir.
Are there other questions of the respondent? Thank you, sir.
Thank you.
Ms. Hadley, you're recognized.
Mr. Spalding violated Section 112.3136 Florida statutes. Clear and convincing evidence proved that Mr. Spalding used or attempted to use his official position, any property, resources within his trust, or performed an action or his duties to secure a special privilege, benefit, or exemption for himself or others. It's simple. The administrative law judge found that Mr. Spalding, the mayor of the city of Bushnell, had access to certain employees and resources of the city of Bushnell. He used this access to charge personal supplies on the city's charge account for a corn maze. He used this access to take city supplies for the corn maze, to which Mr. Spalding acknowledged that other citizens could not. And to be clear, citizens may be able to purchase supplies, not keep them in their possession until they decide to return them to the city. The administrative law judge issued a recommended order with a fine of $5,000 plus public censure and reprimand, after reviewing the record and previous cases which were addressed in the proposed recommended order, my proposed recommended order. Mr. Spalding had a responsibility to his city to follow the code of ethics. But instead, now he wants this commission to reverse the recommendation of the administrative law judge because he didn't know that taking city supplies for his personal use, that he shouldn't do that. This lack of knowledge belies reality when he is taking ethics courses. Mr. Spalding wants this commission to reverse the recommendation of the administrative law judge because he didn't know that he should not use the city's charge account to purchase items for his personal use for the corn maze. This lack of knowledge is incredulous when the evidence shows that he, one, informed Corn Main, the vendor, that he was the mayor, which led the vendor to believe that the corn maze was affiliated with the city, which is the reason that the vendor, Corn Main, let him charge to the city's account. At the hearing, Deputy Finance Director Shelley Reagan identified those employees authorized to make purchases on behalf of the city, and Respondent isn't one of them. This argument is supported by the finding of fact 77, which was not challenged by the Respondent, and which acknowledges and states information from the purchasing policy. At the time, the Respondent did not provide any evidence and still hasn't provided any evidence that's in the record to refute Ms. Reagan's testimony. The Respondent, or Mr. Spalding, erroneously argues that his violation of the procurement policy is not a violation of the law as contemplated by Blackburn versus Commission on Ethics. It most certainly is a violation of the Code of Ethics, Mr. Spalding's actions. The misuse of public position includes the use or attempted use of an official position or any property or resources within his trust for a benefit. Mr. Spalding used the city's charge account to purchase items for his personal benefit. In his own words, he testified that other residents of Bushnell would not be able to charge personal items on the city's charge account at Corn Main. In sum, as demonstrated by the rationale in the recommended order, which is supported by the record, and in my response to the Respondent's exceptions, the administrative law judge, armed with testimony and evidence, drew permissible inferences from the evidence and reached ultimate findings of fact based on competent, substantial evidence. In addition, the administrative law judge's legal conclusions are supported by logical, reasoned consideration of the facts and pertinent law. Respondent's argument in essence is that the administrative law judge should have arrived at a different conclusion. The commission cannot reweigh evidence or resolve conflicts in favor of the Respondent. Those matters are the exclusive province of the administrative law judge. The administrative law judge's findings and conclusions should not be disturbed. Respondent is a public officer who used his position and property and resources within his trust in a manner inconsistent with the proper performance of his office to secure a special benefit for himself. To the extent that Mr. Spalding claims that the recommended order departed from the essential requirements of law by failing to include a specific finding that he acted with corrupt intent, paragraph 82 of the findings of fact states that Respondent's actions constituted an improper use of his position as mayor that was not consistent with the proper performance of his duties. Therefore, the administrative law judge in his recommended order employed the definition of acting corruptly when finding a violation. I stand by my written argument. With any other arguments Respondent may bring forward, I'm not sure if he has any rebuttal time, but with any other questions or concerns, I stand by my written argument. Thank you.
Are there any questions of the advocate, Commissioner Waldman?
Thank you, Madam Chair. your proposed recommended order was a $10,000 fine. And I looked through all the previous cites that you made. Make it easier this way. I looked through the cases that you cited for support, and nothing seemed to approach that $10,000. What's accused here seemed to approach that $10,000 recommended fine. In fact, it didn't even seem the $5,000 that ultimately the judge ordered was consistent with what we've previously done here. How did you come up with $10,000 in light of the cases that you cited, or the orders that you had cited, as opposed to, or in conjunction with what was done here? Why did you think 10,000? It does seem to me we've seen much more egregious things than this. As the Mr. Spotty's counsel said, we're talking a total of $100, and I think you put in it that Mr. Spotty didn't even acknowledge what he did was wrong, and so that's the basis for why you had 10,000. Is that correct?
I believe that, well, as we see, the judge did not agree. He did 5,000. However, I do believe, based on the facts and circumstances of Mr. Spotty's actions, it deserved a $10,000 fine along with the public censure and reprimand. And as you just stated, regarding his, part of the violation is deter further actions. And based on the information that he provided at the hearing, he hasn't accepted responsibility or accountability for his actions. So those factors, including the facts and circumstances of this case, it wasn't just how much it may have cost to have someone deliver the PVC pipes to his personal property. It was all his actions that went along with this case, which is why I asked for 10,000. But as acknowledged, the judge recommended 5,000. And I do believe there are other cases that, with a misuse, that have imposed a $5,000 penalty.
Madam Chair.
Commissioner Gates, you're recognized.
Thank you, ma'am. Madam Chair, I have a question for our Chief Counsel, if I may.
Certainly.
To what extent are we obliged or bound by the level of fines that have been assessed in similar cases in the past? I note that in recent cases, this commission has shown a willingness to increase the amount of fines over fines that have been levied in the past in order for a variety of reasons. But my question to you, ma'am, is to what extent are we bound by the past actions of past commissions in levying fines, the amounts of those fines?
With regard to recommended penalties, the provision of the APA and case law affords an agency with the ability to upwardly increase or decrease a recommended penalty from an administrative law judge, predicated upon a review of the facts and articulation regarding the record in the case. In the instant matter, the ALJ did have the advocate's proposed recommended order and that of the respondent's proposed recommended order. In page 26 of 28 of the advocate's proposed recommended order, she does cite to a series of cases, some of which a $10,000 fine, like Inree Stephen Carter, complaint number 17007, the commission did impose a $10,000 fine in that instance. So the characterization of it being completely anomalous for the imposition of a $5,000 fine predicated upon a misuse of public office finding by an administrative law judge is not in accordance with prior precedent. And this commission, based on this case and this record, can articulate an upward adjustment or a decrease in this recommended penalty of $5,000 and public censure and reprimand.
Madam Chair, may I follow up?
Certainly.
Counsel, I appreciate all of that information. To what extent are we bound, if at all, by the level of fines that have been assessed by this commission in past cases?
Those fines were predicated upon the facts present in those cases. We are not bound by them, especially given the varying degree of pecuniary penalty in our precedents, which goes up to the maximum fine allowed under 112.317, that of $10,000.
Thank you, ma'am. Thank you, Madam Chair.
Are there any other questions of the advocate? Commissioner Carville?
Clarify. So to give you the ability to kind of help something for us, the respondent's attorney was arguing that while it almost sounded like there was an admission that all the actions were done, it was not done corruptly. What would you say to that? Why would you count this as corruption? I know that you dealt with it in your order, but I just want to hear from you.
When you look at what the definition of corrupt is with wrongful intent and in a manner inconsistent with the proper performance of his office, when you look at what happened, let's start with the Corps in Maine. In order to be able to use the city's account, and this is the information in the record, he informed them that he was the salesperson, that he was the mayor. And then when you look at the evidence in the record, you see that it's regarding City of Bushnell and the Corps Maze. The evidence tells us that the Corps Maze has no affiliation with the City of Bushnell. But that's what he led the people in Corps, Maine to believe, the salespeople. And that's the only reason they allowed him to be able to charge on that account. So he led them to believe that the city has some affiliation, and because of his affiliation, he should be able to use that charge account. These were no emergency items that were needed. He could have just waited. Again, this is evidence in the record. He didn't have to, if he didn't have enough cash on hand, he could have waited. Also, evidence in the record tells us that there's a store in the City of Bushnell where he could have ordered. He wouldn't have had it immediately. When he used the city's charge account at Corps, Maine, he was able to take those items with him immediately. He would have had to wait. And regarding using the city, taking the city supplies, those are city supplies. Those are not Mr. Spalding's supplies that he can go take and use at his, whenever he wants to. Those belong to the city. When he had them, that means the city couldn't use them. In addition, and again, the city may have had it where citizens could purchase the supplies, but that's not what Mr. Spalding did. He took them until he got a call saying that there was some hubbub going on, and he was advised to return them. So those were the actions that are inconsistent with the proper performance of his office with wrongful intent.
Commissioner Meigs?
This vendor that had the city account, is that a local vendor, or is that something like Lowe's or some big corporation? Is it?
I can't remember the total number of stores, but there are multiple stores. So no, it wasn't a local in the City of Bushnell vendor.
Where is it?
This one was in Wildwood, Florida. But they do have multiple stores around Florida, if not around the United States.
Any further questions? Okay, Commissioners, what we have before us is a draft final order and public report. It rejects the exceptions proposed by the respondent and accepts the administrative law judge findings. I'll entertain, if you'd like to discuss it, or we can entertain a motion and discuss it at that point, whatever your preference.
Madam Chair, to get the matter before us, I would move that the commission accept the recommended order as presented.
Is there a second? We have a motion from Commissioner Gates, second by Commissioner Grant, to accept the final order and public report. Is there discussion? Commissioner Waldman.
Thank you. Thank you, Madam Chair. I have a difficult time finding the corrupt intent here that would require it. Additionally, I think the $5,000 in light of what we've done previously in other matters is out of line with what was done. It's out of line with the cases that were cited. Some of those cases that were cited that even have 5,000, you actually can see the corrupt intent. They were much more, as I use the term before, egregious than this. This is a matter of, clearly, as testified to earlier by counsel, items less than $100. I think that if we are to find, in this case, that there was the corrupt intent, and based upon the evidence that is at hearing, that a more appropriate fine would be in the neighborhood of $1,000 as opposed to $5,000.
Any further discussion? Commissioner Carvajal?
Thank you. And while I respect the precedent discussion on prior cases, not only are we not bound to that, but I'll also note that while we can't hold the actions to the voice of the citizens who voted for Amendment 12, we can consider the interest of the public in ensuring strong enforcement as we consider penalties. And I'm inclined to support the motion as presented, in part because I think there needs to be a signal that these things are important. I get the oh shucks approach of we're a small town and we do some things, but that's the same thing that has led down many other paths, and I'm not 100% moved in that direction. So I will support the motion as presented at the level as presented.
Thank you. Further discussion? All in favor of the motion to adopt the final order and public report signify by saying aye.
Aye.
Any opposed? Show the show the final order adopted. Thank you for coming, sir. All right, we will move next to item 5, which is consideration of joint stipulation. We have 2 cases. We'll proceed with item number 18-020, in re Kelsheimer.
Madam Chair, for disclosure.
You recognized Commissioner
Thank you.
Carvajal.
As originally noted when this case was presented to, I am a friend of Mayor Kelsheimer's, and it will not affect my decision, didn't affect before, but I just wanted it on the record.
Thank you.
Madam Chair.
Commissioner Gates.
And Madam Chair, last night I received a phone call from my wife, who had received a call from a friend of hers who lives in this community. My wife said, I got a call from my friend, and I know this case is before, they know this case is before you tomorrow, and they have some information. I said, Vicki, we don't want that information. Thank you so much for calling. I love you to death, but I don't want to hear one single thing about the call from your friend. But I want to disclose that that phone call occurred, and the fact that I did not accept any information, and my wife respected that and did not provide me any information.
Thank you, Commissioner Gates. Any other disclosures?
No, ma'am.
Okay. Then we'll go ahead and proceed. Will the parties or their counsel please identify themselves for the record?
Mark Heron on behalf of Joe Kelsheimer.
Thank you. We have before us a probable cause stipulation between the commission, the advocate, and the respondent. After considering all the materials and the presentation of the parties, the commission may vote to approve or reject the stipulation. Complainants have the right to respond in writing to the...
I can learn to understand you much better if I can get familiar with the way you talk.
No one's familiar with the way he talks here. After considering all the materials and the presentation of the parties, the commission may vote to approve or reject the stipulation. Complainants have a right to respond in writing to proposed stipulations. No response was filed. Ms. Miller, you are recognized.
Thank you. Thank you, Commissioners. I'm Elizabeth Miller, advocate for the Commission. Joseph Kelsheimer was the mayor of Apopka. It was determined that he violated the code of ethics by improperly billing the city of Apopka for travel expenses incurred for himself and his wife when they went to Washington, D.C. for an inaugural event. Secondly, the respondent violated the code of ethics by failing to report these gifts that his wife was given because of the travel and the travel expenses that were paid for her. In the joint stipulation, the respondent admits both allegations. He has agreed to a public censure and reprimand, restitution to the city of Apopka of $668, and a civil penalty for allegation 1 of $1,500 and $1,000 for allegation 2, for a total of $2,500. We request that you adopt the stipulation. Thank you.
Thank you. Members, are there questions of the advocate?
Madam Chair,
Commissioner Gates?
thank you. What was the total amount, the value or the total amount of money that was involved in this matter?
Through the chair, that was in dispute, but it was also unclear. There were various amounts that were provided to the parties. We settled on $668, which is what he paid, Mr. Kilsheimer paid for his wife's travel. There were other expenses. For example, a second hotel room had been booked in Washington, D.C. during a peak season. It was very costly. It was not canceled, and Mr. Kilsheimer stayed elsewhere. However, Mr. Kilsheimer's assistant took the blame for that. So it was just we were very unsure of what all the expenses were.
Madam Chair, so you have agreed, both parties have agreed that $660 worth of value is what is at issue here.
Yes, sir, that's correct.
Thank
That's
you.
what the city owes, or
Thank you,
he
Madam
owes the
Chair.
city, excuse me.
Are there other questions from other commissioners? Thank you, Ms. Miller. Mr. Herron, you're recognized.
Thank you, Madam Chair, members of the commission. As the advocate indicated, if this case went forward, there are a number of issues that it's unclear as to whether there is violations of the code. As the advocate indicated, Mr. Kilsheimer has accepted responsibility, which I think is an important issue when you bring these settlements before you. And he's no longer in office in that city. And so we would urge you to adopt the joint stipulation. And if you have any questions, I'm more than happy to answer them.
Thank you. Are there questions of the respondent?
Thank you.
Thank you, Mr. Herron. So before us, we have a joint stipulation. Is there a motion?
So moved.
A motion from Commissioner Grant. Is there a second from Commissioner Gilzine? Discussion on the motion. Commissioner Waldman.
Thank you, Madam Chair, and I certainly support the joint stipulation and the motion, but this is sort of what I was referring to earlier in the case before us, that our fines should be consistent with really what's going on, and while I stated before I thought that the amount of the fine was not consistent with what the actions were, this is a perfect example of something that should be more based upon what we did earlier, but I do find it appropriate in this instance. So I just wanted to say that I think that we should look to some level of consistency as we move forward. Thank you, Madam Chair.
Thank you. Are there other comments from commissioners? I have one, someone in response. Acknowledgement of responsibility, in my view, does weigh heavily in consideration of penalties. Also, the ability to work with the parties and come to an agreement and avoid further taxpayer process, I think, is also another factor that can weigh into the matter of a differentiated penalty, so that's my comment there. Commissioner Waldman?
So, it's an interesting thing that you say, Madam Chair, in terms of accepting responsibility, and because what, in essence, you're asking people to do who don't think that they did something wrong, is to say, I did something wrong just so the penalty will be less. And I think there were different circumstances in the case earlier that would indicate that maybe it wasn't quite the same level as somebody else in another city. Somebody in the city of Fort Lauderdale doing it would be a lot different than, as I thought, the city of Bushnell, or whatever town. So you have to look at it that way. Not everybody's going to always agree just because a court finds that you're guilty, that they're still wrong. And I can't say that you have to acknowledge it in order to get less of a penalty. I just don't think that that's appropriate. And that's all. I mean, but as I said, I think in this case, certainly, and I know Ms. Miller advocates very strongly, so if she's come to that amount, I believe it's appropriate in this case.
Okay. Any other comments? All in favor of approving the joint stipulation signify by saying aye.
Aye.
Any opposed? Show the joint stipulation approved. We will move to case number 18-141, N. Jackson. Any disclosures? Will the parties or their counsel please identify themselves for the record?
Mark Aaron on behalf of Andreana Jackson, and I'm substituting for pitch hitting for Van Tuning.
Okay. We have before us a post-probable cause stipulation between the commission, advocate, and the respondent. After considering all materials and the presentation of the parties, the commission may vote to approve or reject the stipulation. Complainants have the right to respond in writing. No response was filed. Ms. Miller, you're recognized.
Thank you, Elizabeth Miller, advocate for the commission. Commissioners, this respondent served as the vice mayor of the city of North Bay Village. There were 4 allegations. The commission found probable cause on only one of those allegations. The respondent has admitted the allegation and agreed to a public censure and reprimand and a $1,500 fine. Admittedly, this is a very low fine for the facts of this case, but I believe it's a fair resolution of the case based on these factors. The penalties authorized in an ethics case would be removal from office, a civil penalty not to exceed $10,000, restitution, and public censure and reprimand. There also could be forfeiture of not more than 1/3 of her salary in this case. Based on the same facts, the respondent was charged criminally with extortion and abusing her position. She pled guilty to both the charges on July 22nd, 2020. Adjudication was withheld on the extortion by officers of the state of Florida, but she was adjudicated guilty on exploitation of official position. She was removed from office, ordered to serve 100 hours of community service, and pay $3,950 in fines. She received 1-year probation. She was barred from running for public office for 1 year, and she was required to apologize to the citizens in her community. For those reasons, I believe public censure and reprimand and $1,500 is appropriate. Thank you.
Thank you. Are there questions of the advocate?
Madam
Commissioner
Chair.
Yates?
This is a question for the advocate, and also I'd like a comment from our chief counsel. My understanding from our counsel is that we are not bound by past actions as to the level of penalties that we apply in particular cases, that we're not legally bound. But now am I hearing that the reason why we are recommending, or the reason why you are recommending in effect, a lower penalty, a lower fine in this case, is because the courts have already punished this individual in a substantial way or in a way that actually exceeds rather substantially what's being recommended here. I realize that we can take many factors into consideration in developing a settlement or making a decision, but I'm asking you, and I'm asking counsel to comment, is your recommendation here in part reliant upon the fact that the vice mayor has been, former vice mayor, has been punished by the criminal courts?
Through the chair. Yes, sir, and the reason is the criminal court has done basically what we can do other than the $10,000 fine. And she did admit to the allegations, saved us from going to DOA and rolling the dice, saved us a lot of cost by not going to DOA. And it was a bargain, a plea bargain that we made. But the main reason is the criminal court instituted those penalties that we could have. That I could have asked for had we won at DOA.
And another way that someone may approach this would be to say, well, if the criminal courts have found that this individual has violated the law and they've imposed severe penalties, that ought to really put starch in our collar as to the application of penalties. So one might, a logical person might go either way. And I gather here that the reason that you are doing what you're doing is, as you've just indicated, you want to avoid the expense, the time, the trouble to go to DOA and, as you say, roll the dice there. Counsel, am I getting this right?
You are absolutely accurately characterizing the articulation by the Commission's advocate, which is providing information forming the basis of her belief that this stipulation represents an appropriate resolution of the case at this time and predicated upon, in part, the conservation of additional expenditure of public funds. It is to be evaluated, though, by this agency, the trier of fact, in its contemplation of the document before you and its approval or denial. It is appropriate for you to utilize your authority, which is vast in this area, but she is providing you with a holistic articulation regarding how this dollar figure and the public censure and reprimand has been proposed and agreed to thus far.
Madam Chair, just to follow up. So let me ask you this question then, counsel. Within the law and within the bounds of our rules and policies, could a reasonable person use the fact that there's been a criminal court that has heard this matter and found this person guilty? Could a reasonable person also conclude that this would add further weight to any penalties that we might impose, and therefore result in a higher penalty? Would that be I'm not asking you to vote, but I'm asking you if that could be a logical conclusion within the law and within our practices.
Absolutely. It would be an absolute, based on the same factual predicate, a completely reasonable determination by the trier of fact with respect to the same facts.
Thank you. Thank you, Madam Chair.
Certainly. Mr. Hare?
Mark Heron, stepping into the batter's box for Ben Cooney on this issue. And again, as noted in the joint stipulation, the advocate's reasons for the penalty are articulated in the sense that, about the criminal court action, that's in paragraph 6 of the joint stipulation. But to Commissioner Gates's argument specifically, he asked whether a reasonable person could conclude that the criminal conviction is a basis for enhancing the penalty here. I would submit that likewise, a reasonable person could conclude that the criminal action and the penalties imposed by the criminal court are a basis for this commission dismissing this complaint. And the commission, in its history, and I've been doing this since the late 80s, early 90s, has done that. When people are convicted of crime and there's the identical issues before this commission, the commission has dismissed those complaints. In this case, the commission's advocate has determined that it's appropriate to proceed and has recommended a penalty that I would submit, given all the facts and circumstances, are reasonable. And I would ask that you adopt the the joint stipulation of fact, law, and recommended order as proposed. Thank you.
Are there questions of the respondent?
Madam Chair, I don't have a question, I just have a comment. You are a very good friend to your colleague.
Well, I know if the commission doesn't adopt this, Ms. Miller will have another opportunity to negotiate with Mr. Cooney. Okay.
Very good. Okay, so for purposes of starting any discussion, is there a motion regarding the joint stipulation?
Move it be adopted as presented.
Is there a second? Second, we have a motion from Commissioner Grant, seconded by Commissioner Carvajal to accept the joint stipulation. Is there any discussion? Commissioner Carvajal.
To reinforce what the respondent's very strong representative mentioned, there have been very disturbing times where we have waived or dismissed cases since I've been on, and I recognize that at this stage it's really a matter of a negotiated balance. It's not a statement that there shouldn't be more thrown at the book at them. I am taking the totality of the arguments from the last few cases to make this comment. I think this group of folks at the dais, even if they have been different folks, have taken comments of admission of guilt and apologies and done things that maybe we shouldn't have done and let people off because they are contrite and we truly believed it. And there are cases, maybe this one in my mind, that should be fined more, but we're relying on the advocate to kind of say, this is what we can negotiate at this point. We can go more, we could potentially collect more, but it will cost us another $10,000 to try the case to capture $10,000 here. And we have often argued that our staff, including the advocates to some degree, are stressed with the caseload that we have. And I know that this is a long answer, discussion, but it was really just to acknowledge everything that we've done here as some of us come closer to the end of our tenures, to remind folks that, the numbers aren't set, and we have to be careful because they do set a precedent to some degree, whether that's the legal word that's accepted by this commission sometimes or not, but we want people to improve their ethical behavior. I think that's what we're trying to steer towards. We're not here necessarily to just punish people. And these are interesting things that come before us, and I like when somebody acknowledges that they have done something. So.
Thank you. Commissioner Ankers.
Not so much relevant to this exact case, but while we're talking about the issues of the amount of penalties, and one of the factors that's been discussed in a few cases this morning is the amount that was used for the purchase or borrowing, value of property. And personally, although I'm hesitant to make generalized statements about cases, in fact, I would just suggest, while I have the chance before I'm kicked off, is that $100 can lead to a $100,000 profit for somebody. So it's not necessarily the value of the thing itself, to me, whether that's a high or low number that should impact the penalty, because there are always potential consequences from the spending of that little bit that has a great pecuniary gain in favor of a person and not be a public benefit.
Thank you. Any other comments? I just have one, and that is to take issue with the notion that we took actions that we shouldn't have taken. I'm sure all our actions were always
Sometimes
appropriate,
you
always.
disagreed with me, though, so.
I'm just joking with you. Okay. We have a motion before us to accept the joint stipulation. Any further discussion? All in favor signify by saying aye.
Aye.
Aye. Any opposed? Show it approved. Thank you. Okay, next up is item 6, consideration of financial disclosure appeals. All 6 of our items are have not requested hearing, so there's no oral presentation on the content of these appeals unless a member requests it. But I do want to recognize Staff Attorney Suhail Chabra for an oral amendment to the draft on order item 119-078.
Good morning, Madam
You are
Chair.
recognized.
Good morning, Madam Chair and Commissioners. Sohail Chabra for the Commission. In Financial Disclosure Appeal 19078, Deborah L. Butel, if it will be the will of the Commission to approve the waiver of the fine as reflected in our draft order before you, the staff requests the ability to orally amend the draft order. The amended final order would then just reflect the waiver and the rescission of the default order which was previously entered for the fine by the Commission on September 15, 2021. So the staff is just requesting for a leave to amend.
Okay. Let's go ahead and deal with this case. Do we have a motion?
To put it on the floor, I'll accept the motion as presented for 19078, but I do have a question about what was just presented to us.
Okay, I think what we're seeking is the ability for it to be amended as specified as presented to us rather than what is before us so that it can be accurate.
Then I could make that motion if I understood what you just said. What is being amended in particular?
And I'll second it so that you have it before you.
Okay.
There is a previous default order for the fine, so if the Commission chooses to waive the fine, we will amend the order to reflect that waiver of the default order and the fine together. That is pretty much all.
Thank you, so it would just add one more section that says the previous order reached default. Thank you very much. I will make the motion to accept
Okay,
with
we
the
have,
oral amendments.
we have a motion from Commissioner Carbajal,
Second.
second by Commissioner Gates to accept the order as amended. All in favor say aye.
Aye.
Any opposed? Show that approved. We have items 2 through 6. Are there any disclosures that are required in those? And is there a motion to hear them en banc?
So moved.
I have a motion from Commissioner Waldman. Is there a second? Second from Commissioner Ankers. Okay, and now, is there a motion to approve those?
So moved.
From Commissioner Gilzine, second from
I'll second.
Commissioner Carbajal. So we are, it's just to consider all of them together, and now we're gonna consider to approve.
But we didn't vote on the first one.
Oh, I'm so sorry. Okay. Let's take it back. All in favor of considering them en banc signify by saying aye.
Aye.
Any opposed? A motion to approve. All in favor say aye.
Aye.
Any opposed? Show that approved as well. Thank you. Next up is our annual report, which was included in your materials. Once adopted, this report will be provided to the House and Senate and be published on the Commission's website. If there are any questions regarding the report, Carrie's going to be very excited to answer them. Are there questions for Carrie regarding the annual report? Is there a motion?
I'll move to accept the annual report as presented.
Thank you.
Second.
We have a motion from Commissioner Carbajal, seconded by Commissioner Grant to accept the annual report. All in favor?
Madam Chair, may I make a comment before we vote?
Certain.
I apologize, but if I was going to make any comments to amend, but I wouldn't, it's that, you know, it doesn't really give reference that the caseload has been about the same as it has historically during a period when we had fewer investigators, during a period where we had COVID. And I know that we have expressed a great bit of angst at sometimes how long things take. But to manage, you know, the business of Florida with just shorthanded with the situations we've been dealing with, I know that we thank our staff enough, sometimes individually, sometimes in mass, but it really should be noted because it does not come across the hard situations that they were dealing with the caseloads. And by the way, those of us driving them and pushing them really, really hard. So
Right.
just wanted to make that public statement just in case.
Right, and I thank you for that comment, and I did in my general comments actually note that there has been a reduction in the backlog, and that's certainly largely due to the work of the staff, and I know it's Carrie's mission to reduce that further. Any other comments?
I
Madam
should have
Chair.
started with your comments were beautiful and wonderful and
Oh,
some of the
yeah.
best I have ever read.
Ever. Commissioner Gates.
Yeah, Madam Chair, I would agree. It's great literature. But I really do believe that there ought to be some reference, if there could be, Carrie, to the fact that notwithstanding the challenges that have beset this commission and all government agencies associated with COVID, and, you know, that there's been no diminution in the number of cases that have come before us, and no let-up in the amount of work and results that have been achieved. I think it's important to say that. I'm on a couple of other boards and commissions that report to the legislature, and I know that there's sort of standard language that's being put in all of those saying, because of COVID, you know, we did less, or because of COVID, somebody that we gave a grant to did less, or was able to move, you know, only at a slower pace than we thought. So, you know, without reaching over and slapping ourselves too hard on the back, I think we should give staff credit for moving us along, and our chair credit for moving us along at a pace that some agencies are not able to do under these challenges.
So are you recommending we make an amendment to that section of the report specifically stating that despite the challenges of the pandemic, the commission continued its consistent pace of work?
Yeah, some reference like that, if Carrie is able to do it without a lot of problems. Yeah,
Would that be all right?
Through the chair, I'd be more than happy to add that.
all right,
Okay,
great.
thank you. Okay, so we do have a motion before us to approve. Did you mean that motion to approve with the amendments that we just
I
talked
would
about?
absolutely accept that.
Okay,
Can I make just one more comment? too,
Certainly.
to add on to what Commissioner Gates has so eloquently said. I think we need, bearing in mind that this is going to kind of be a handbook that goes to the legislature, that a lot of people are going to look at as they make decisions, including funding for this commission going forward. And I think we need to be maybe a little bit more forceful in pointing out that not only have we had a difficulty with reduced workforce in dealing with the complaints, we have also had to commit, I don't know how many person hours to the project of going digital. Hours and hours were spent by our staff, which meant that those hours were not able to be spent doing the things that we normally do. And while we think that this is a great move forward, it possibly is going to require some staff additions as we move forward, and perhaps some of that kind of language can be inserted in there so that when people look at our report as they make various decisions in the legislature, mainly funding, that they would have this full information.
Commissioner Ankers?
Mine's not relevant to that, but
Okay.
it is to the report. And when I was chair, I found this statement that the chair has to write to be a little bit difficult to figure out what is the right message to convey when one is conveyed every year, what new or different are you going to say. And when I read yours, I was reminded that when my daughter was maybe 11 years old, I brought her for her civics lesson to sit out here, and when we got in the car, she said, "Mom, please don't ever make me do that again." I haven't made her do it again, but I am going to make her read your statement because I think that it's a good explanation of what not just the Ethics Commission is, but what ethics are.
Thank you.
She will not write you a thank you. I will.
Well, thank you, I appreciate that.
Madam Chair, I don't mean to prolong the agony, except that if we look at what the legislature is doing right now, and we look at the House language of a bill that is moving very quickly through the House, the legislature is directing us and acknowledging that we will be doing more work as a consequence of Amendment 12. And I think we've discussed it here, and I know, I really believe that we acknowledge, our staff acknowledges, that we will have more work to do. And now, if the House language passes, which I believe the Senate will accept, we will find that we are being directed to do more investigatory work as a consequence of Amendment 12, as well as more cases coming before us. So I would agree with Senator Grant that there ought to be some reference made to the fact that we anticipate we are doing more because of the digital reporting, and we anticipate that we will do more as a consequence of Amendment 12. Because I agree with Senator Grant that there are those in the legislature who may read this, and it does provide a basis for why Carrie may add staff, as we have empowered her to do, if she has to, in order to meet the increased scope of work that this commission has.
Okay, so let me, as I understand it, we want to consider making comments regarding the workload that has been done with respect to e-filing and the potential for increased workload with respect to the implementation of Amendment 12.
Yes, ma'am.
Okay, is that part of the motion that when you made that, you knew you were doing that? Very good. All in favor of approving the annual report with those amendments signify by saying aye.
Aye.
Aye. Any opposed? Show that approved.
I thought the report was pretty good to start with.
Yeah.
Okay. Next, we will go to reports. I do not have a written report. Carrie?
All right, with your approval, I'd like to jump around a bit in terms of the order they are on the agenda, and I'd like to start with a brief legislative report. Just to update you, since mail-out was a few weeks ago, as Senator Gates alluded to, the House Bills 7001 and 7003 concerning the implementation of Amendment 12 are moving right on through. 7003, which deals with judges and justices, has been placed on the second reading calendar, and 7001 is in Rules Committee. In relation to the enhanced financial disclosure recommended by this commission, We have bills in both the House and Senate, and those are moving through as well. The Senate bill, I believe, is going to be coming up in its last committee soon. And in the House, it's now been made a committee substitute. The PI committee also amended on some technical changes to improve the bill in terms of its implementation. Also incorporated a couple of glitch items related to the e-filing that was passed a few years ago, and we're thankful for those to be there. And we are hopeful that the Senate bill will comport with that by the time it is all said and done. If there are not any questions.
Any questions regarding the legislative update? Go ahead.
Okay, moving on to everyone's favorite subject, e-filing. We are live with e-filing, or EFDMS as we refer to it. And that happened on January 1st around noon, and there were members of your staff as well as the IT team working on New Year's Day and on conference calls as we went live to deal with any unexpected items that came up. That went relatively smoothly, and then on the 3rd, we officially rolled out registration codes to the agency coordinators, roughly 1,800 of those. Those are the people who provide us with the list of people in service as of December 31 of 2021 who will be required to file in 2022 this summer for both Form 1 and Form 6, even though Form 6 filers will be the only ones filing electronically. They have begun logging in. They have begun using the system. It's not been perfect, but we've not had any major mishaps, and the IT team has been responsive in working with us, prioritizing hot fixes and additional rollouts. We've had roughly 1/2 of our coordinators logged in and working on their lists. Last week, staff started reaching out by telephone to each coordinator who had not yet logged in to try to encourage them to log in while they were on the phone with us so that we could get them in and get them going on that list because they're supposed to get that finalized to us by February 1st. And that is because Kim and her staff will need time to clean up that list a little bit before we roll out to Form 6 filers their official invitation to register March 1st. Just prior to that March 1st invitation, we will be rolling out some enhancements to the electronic filing system that will include some enhanced public search features. It will also include, based on feedback from this commission and others, the ability for filers to upload a spreadsheet, technically in a CSV format, of assets to the system where it will incorporate that so they will not have to individually place those within the system. I saw a demo of that. It looks really good, and so I think a number of filers, particularly those who have a number of assets to report, will be pleased to see that enhancement. We do have a few filers who have gone in. Already it is open to filers, even though we have not officially rolled out their invitations to register. Some people need to file amendments. They can contact our office and we can give them access to the system. So we are moving right along, and we've experienced every single emotion along the way, but I do want to again recognize the e-filing team and the House and Senate for their support in this, and recognize Kim and Lynn for giving up some of their holiday in order to make sure that this was running smoothly. So we're off.
Okay, that's great.
And finally, Executive Director's report. I don't have much to add except for, on behalf of the staff, our sincere gratitude to you all for the comments you made earlier and for encouraging us to stretch ourselves and look at ways to improve on what we already know to be good in order to make it great. We are lean and mean and always looking to be good stewards of taxpayer dollars, but we are certainly maxed out at the moment. So we appreciate your encouragement. We've also, as noted in the report, we are down one investigator again, and we are currently advertising and hopefully interviewing soon for that. And we have added a new part-time clerk to our staff. He's here today. Alex Rudd is in the audience, and please welcome him to our staff. If you call the commission, you might get to speak to him. And we're thrilled to have him on board. Many hands make light work. And finally, I would like to turn it over to Vice Chair Grant for a presentation.
Thank you very much. As Vice Chairman of the Commission, it is my opportunity and my honor to present a plaque to our Chairman. Joanne has done an admirable job this past year serving as Chairman, and in spite of some challenging personal problems at home with medical issues and deaths in the family and various things, and I know it's been a challenging year for her, but she has given yeoman's work to the Commission, and this is her final meeting as Chairman. She's not going anywhere. She's just not going to be Chairman. And so we have this plaque, and this is a little different than the plaque that we normally give to our Chairman. This, on the back, it has a place where you can hang it on the wall, and you can walk in a room and have remembrance of your service. But it also has an adaptation on the back of it that it can be used as a drag anchor on her fishing boat. She is an avid fisherman, and because of her health problems in her family with her husband, she's been denied the opportunity to fish for a little while, and she's anxious to get back on the water, and this plaque can go with her. She can hang it in the cabin on her boat, or she can use it as a drag anchor, whichever. But Joanne, we deeply appreciate your service as our Chairman. Thank you very much.
Thank you very much. I promise not to use it as an anchor on my boat, which is too small really to have much of a cabin. It has been an absolute pleasure to serve as chair of this commission, and have enjoyed and will continue to enjoy the relationship that I have with all of you and all of our staff, which leads us to the next, and thank you so much. Leads us to the next item on the agenda. As you know, statutorily, the chair can serve for only a year, and my time is up. And so it is time to select a new chair to be effective on the 1st of February. Commissioner Meggs?
I'd like to make a nomination, and I don't know if it's a package deal or you want them one at a time.
Let's go ahead and make nominations for chair, and then we'll have nominations for vice chair.
I'd nominate Commissioner Grant for chairman.
Okay, we have a recommendation for Commissioner Grant. Is there a second?
Second it.
We have a second from Commissioner Carbajal. Are there any other nominations? Seeing none. Any discussion? All in favor of electing Commissioner Grant as the chair of the commission, signify by saying aye.
Aye.
Any opposed? Of course not. Congratulations, sir.
Thank you very much. It'll be an honor.
Very good. And we'll go ahead and proceed with nominations for vice chair. Commissioner Meggs.
I would nominate Commissioner Gilzine as vice chair.
Okay. Is there a second?
Second.
Second from Commissioner Gates. Are there other nominations? Seeing none, is there any discussion? I think you'd make an excellent vice chair. All in favor signify by saying aye.
Aye.
Any opposed? Of course not. Congratulations, Commissioner and Chairman and Vice Chairman.
Thank you.
Would you like to make any comments, Commissioner Grant?
Well, I look forward to this. This is actually my third lap around the track on the Ethics Commission. The Commission on Ethics was created in 1974 by the legislature. And I got a call from the Speaker of the House asking if I would serve on the commission. And I said, well, tell me, what is that? I didn't even know. He explained, and I said, well, yeah, I would be delighted to do that. And so he appointed me, and so I was actually the first commissioner ever appointed to an ethics commission in Florida. And then the Speaker and the President, and back then the Chief Justice of the Supreme Court made an appointment, and along with the governor. And we assumed office on June 1st, and the legislature provided that when qualifying occurred in July, everybody had to fill out the forms. There was no lead time, and we all came to Tallahassee, and the governor, we didn't have an office back then, and the governor let us use his conference room, and in a course of 30 days of working long days, we came up with all of the initial forms, many of which have been changed, but some of which still exist. And
I was wondering who to blame.
yeah, that's where the blame is. And so I served 4 years then, and then ran for the legislature and served in the House and Senate. And when I got out of the legislature, Governor Bush called me and asked me if I would serve on the commission again. So I did for 4 years, and then a couple of years ago, Governor DeSantis called me and said, would you serve on the commission? So here I am. And I guess I just don't know how to say no, but it's been a wonderful opportunity over these years to watch the commission grow in its area of responsibility and the competence of our staff. I think we have just an incredible staff, and I can say we have the best staff today that we have ever had in any of the 3 times that I've served on the commission, and that's not taking away from many great people that have served in the past. But under Carrie's leadership, she has established a tremendous staff and built on the shoulders of previous people who served in that position. And so I'm deeply honored, and will look forward to being your chairman during the coming year. And it's nice to know if I decide not to show up for a meeting, that Commissioner Gilzine will admirably work in my place.
Well, we need you to show up.
Commissioner Gilzine, would you like to make any comments?
Just honored for the opportunity to serve, and I would be honored to actually make our motion to adjourn.
I was just going to ask if you would do that. All
So
in
moved.
favor? We are adjourned. Let's take a short break, maybe 15 minutes, come back at 10:20, so we can move through our executive session.
Thank you.